Joining me now, Judge, how you doing today?
I'm wonderful. How are you?
Good. Thanks so much for joining me. So, what are your thoughts on that? Why bring in that witness?
Well, when you're trying to either prosecute and or defend the case, just generally speaking, you want to bring in as many witnesses who can really paint the picture of not only a specific incident, but also maybe the overall character of the case that we're dealing with. So in these cases, you're going to see as many witnesses as they can bring so that they can actually paint the picture as to what they're trying to prove, whether it's a defense perspective or prosecutor's perspective. So you're going to get a lot of witnesses. And sometimes the testimony may seem like it's not relevant or it's not as important, but every bit of information will determine how that jury comes back with their verdict.
All right, and LA County Deputy Public Defender Philip Dube. Philip, thanks so much for joining us. What are your thoughts on that witness?
Well, the prosecution, first of all, has to establish a timeline of when Kathy disappeared. The heart of the case is that the missing wife, who they presume to be deceased, provides the motive for the death of Susan Berman. So if that's the case, they have to take everybody back in time to introduce the jury to all the witnesses who last saw Kathy Durst alive. So they're bringing in all these witnesses, whoever they have from back then, which, by the way, is kind of unbelievable when you consider it was 40 years ago, give or take. Additionally, they want to attack Bob Durst's alibi that he's giving. Apparently, he's saying he was with certain people, he was with the neighbors, he dropped her off at the train station, then he went to go have drinks with the neighbors. They're bringing in all these so-called alibi witnesses to discredit all the statements that he gave to the police. So again, this is a process of accretion. In other words, they're just like little baby building blocks to get to the heart of the Susan Berman murder. And we're still in that embryonic stage, even though it seems like it's been an eternity.
I mean, Judge, this is a very unique case, but this case is about the murder of Susan Berman, but we keep hearing so much about Kathy Durst. What's the strategy there? Is this case about Susan Berman, or does the prosecution have to really prove first that Durst killed Kathy Durst?
Well, it doesn't hurt to prove that he did the first murder, because obviously that's going to paint the picture of him as being someone who will kill at will. And I find it really interesting, just as it was said, the fact that these are incidents that happened so long ago, you really wonder the memory of all the witnesses who are telling, whether or not he was with them or where he was or the conversations. So that's a challenge in and of itself for the prosecutor to actually make these witnesses believable, considering that they've had this information or tried to retain this information for so many years. But yes, I think that by mentioning Durst, it continues to paint the picture that this is a murderer, basically, and that he had to commit these other crimes also.
And Philip, I mean, what do you make of the defense's strategy so far in the case? Does it feel like it's coming together?
Well, there's an old expression in criminal defense, and that is the devil is in the details. Okay. The goal, obviously, is to attack these witnesses as to various details and to try to make them unbelievable, incredible. First of all, that they're biased, that they've probably had some type of conversations with the prosecution and denied any interviews then with the defense. So it looks like it's not a fair fight. It's almost like a David and Goliath type fight. And juries tend to be sympathetic with people who are put in a position to have to defend from acts that occurred decades ago. So the witnesses that they're putting on better get their ducks in a row. Otherwise, juries might take unkindly to their theory.
All right. Well, let's just switch gears for a moment because we've been following the case, the trial out in Iowa. It's in the murder case of 20-year-old Molly Tibbetts. The defendant, Christian Bahena Rivera, stands accused of stabbing Tibbetts to death and placing her body in a cornfield. Yesterday, the jury deliberated for roughly 3 hours before going home for the night. Deliberation resumed this morning at 9:30 a.m. Eastern. And for the jury makeup, we don't know who the alternates are just yet, but we do know, barring any issue that would require an alternate to come back to the jury, it consists of 3 Hispanics and 9 white jurors. Ages range from 19 to 71, with 5 female and 7 males making up the jury of 12. The prosecution says Bahena Rivera is Tibbetts' murderer. They point to his confession and the fact that he led authorities to her body. But the defense is saying the opposite. They say that the wrong guy has been arrested for this crime. The defense points to the lack of looking at other suspects, including sex offender Ron Pexa and Tibbetts' own boyfriend, Dalton Jack. We'll bring you inside the Iowa courtroom as soon as we have word on the verdict. But in the meantime, let's take a listen to yesterday's closing arguments.
With
3
him.
Hispanic, 9 white jurors. Judge, what does that tell you about sort of how important it is in this case to really assemble the right jury for this?
Yes, as you know, jury selection is very, very important to the defense of a case as well as the prosecution of the case. And as a judge, you want to make sure that the jury is truly a makeup of the community. So we have an obligation to make sure that neither side is trying to really tip it toward their benefit. So in this particular situation, the fact that there are 3 Hispanic individuals, that stands out to me because, in honesty, that's all you really need to get that hung jury. So it's a good jury, I believe, for the defense, but it's a fair jury when you speak about it all around because you have a good representation of the community, and at least the defendant cannot say that he's not represented on that jury.
And Philip Dube, public defender, joining us on this again. Philip, what are your thoughts on this from your side? Where do you see the defense going from here?
Well, quite frankly, I think so far they've got a moral victory. This jury has been out for quite a while on some pretty powerful, pretty compelling evidence. On a personal level, I actually think he got a pretty impartial jury, given the fact that this jury has been out as long as they've been out. And frankly, I think that if this case were tried in Central, Latin, or South America, a jury could convict on these facts. So I don't think he's deprived of his right to an impartial jury. I think he got a jury of his peers, even though he's out in the boondocks of Iowa.
Yeah, I mean, and if he is found guilty, is there any recourse? Is there any further step that the defense might take in this case?
Well, of course, it would be on appeal. You bring a motion for a new trial. But, quite frankly, one of the biggest mistakes the defense did was putting Mr. Rivera on the stand, because I think any hope that he would have at a reversal on appeal would be to attack the voluntariness of the confession that he gave to the police. But I think a higher court would find harmless error given all the incriminating and quite frankly, preposterous things that he said when he took the stand. The Court of Appeals or whichever reviewing court looks at the record below is going to say, well, the jury obviously weighed his testimony against the physical and the circumstantial evidence and frankly just didn't believe him. So whatever error that they might find is going to be harmless.
All right. Well, let's take a quick break, but much more on this trial when we come right back. Stay with us. I mean, is the jury going to buy this?
Well, it's always a good strategy to humanize the victim, give her that spark of life. The problem that we have here is, you notice he never once says that my client is innocent. He never uses the word innocent. Instead, he just pounds reasonable doubt, unproven, as opposed to he should be exonerated, he did nothing wrong. Instead, he's just a victim of the system. You got to keep in mind that when he took the stand, in my mind, he had, quite frankly, a pathological poverty of emotion on the stand. I saw absolutely no fear. I saw absolutely no remorse. I saw no apprehension on his part. Instead, it was a very, very cold, sort of surgical, cerebral response to the questioning that made him look like a very unsympathetic defendant. Quite frankly, very, very icy. Yes, he did do a lot to try to humanize him regarding his character, regarding the fact that he came to this country to seek the American dream, that he is a family man. But, the prosecution came back swinging and say, well, that's all well and good, but I guess he started his criminal profile with a doozy. He started with a dilly. And when you have this quantum of the body of evidence that you have in this case, it's really, really hard to use his good character and the fact that he's a hardworking farm boy as the undergirding for reasonable doubt. But I give him an E for effort, and I give him kudos for trying to spare his client of life behind bars.
Yeah, it's fascinating to see him up on the stand, and like you described, a poverty of emotion. Judge, we talked about the jury selection in this case. I mean, all of the emotion around this trial, all the emotion around the murder of Molly Tibbetts. Do you believe that the jury can come back and has a clear head about all this?
I believe they can come back with a clear head, and I believe they can come back with a clear decision. But there's always pause when the jury is out for an extended period of time. You hope that they get those decisions, especially as a prosecutor. You hope that you've made a slam dunk. But Philip said it correctly in the fact that, not once did the defense attorney say that his client was innocent. And I believe he should have played with not only reasonable doubt, not only, you must acquit, but also he didn't do it. But they didn't say that. So that leaves doubt in my mind as a juror sitting there listening to all the evidence and now evaluating it in the back, saying to myself, well, his defense attorney didn't really seem to believe in him either. So it's going to be pretty interesting, but I do believe that they will come back with a clear decision in this matter.
All right, well, let's play more of that closing argument from the defense. Let's take a listen.
Well, at the very end, I like the fact that he, just analyzing it. I like the fact that he got really demonstrative with his stabbing of his hand. Okay, that works a little bit. And the fact that he said they had unlimited resources. If he could pull it all together and continue to pound in their head that his client is innocent and that he didn't do it, that will help because he's painting these different pictures, unlimited resources. They're using excuses for the weather. They didn't have a witness, no witnesses, no eyewitness. But then he has to keep ringing the theme that his client did not do it. Not so much that they can't prove it, but that he didn't do it. That's what he needs to focus on.
All right, well, much more on this case when we come back. We're just going to take a quick break, so stay with us. About his demeanor on the stand when he was there, icy. You described it as a poverty of emotion. Can you sort of elaborate on that?
No, it was a very, very flat affect about him. Recognize that he went through a very, for lack of a better term, traumatic event. Two masked men supposedly converged upon him in a trailer right after he gets out of the shower. I'm assuming he's only wrapped in a towel. And the next thing you know, he's taken at knife and gunpoint out into the, rural Iowa cornfields to abduct Molly Tibbetts and end her life. It's a fantastic tale. It reminds me of almost like a comic strip out of the Dick Tracy era, where you have a caper and the coppers. The only thing missing is breathless Mahoney. It's absurd. And then to wonder why more work wasn't done to try to track the boyfriend is because it didn't matter. His story is that two masked men took her out. And it would seem to me that whatever DNA was found in the trunk only led to Christian. Unfortunately, it did not lead to the boyfriend. So he was eliminated.
Well, let's see him. We have the clip now. This is Christian Bahena Rivera on the stand in his own defense.
Well, there's another old adage, and I say it all the time, and that is the road to state prison is paved with many a man who took the stand. If his version, right? If his version is that he was too afraid to call the police because it would look bad, then why did he tell the investigating officer that he did it and lead her to the body? It just the two versions are so incongruous it doesn't make sense. And yet on the stand he has this very stoic, stolid, again, cold affect in recounting what would otherwise be a very, very traumatic event.
All right, well, let's just go to the prosecution's closing arguments because they directly respond to this defendant taking the stand. Let's take a listen. Common in your courtroom to see cases where you have all of these different theories trying to spin a jury into confusion.
You know what? This case here is really unique because you have the confession, you have, he's taking them to the body, and then all of a sudden it's not me, it's some other person. So this is a very unique case in the sense that there are so many different theories. But I do find it interesting, just like, the prosecutor said, he can't be in more than one place at a time. And most importantly, I would have hit home the fact that don't buy his testimony as him wanting to stand up and tell his story. He's a murderer. That's what I would have said, because in reality, the evidence is so stacked against him. But yes, to answer your question, there is a lot of information going to this jury, which may lead to at least extended, deliberations. Hopefully they'll make the right decision, but the deliberations will be extended because there's so many pieces of evidence that they have to at least consider and break down.
Philip, your quick thoughts before we take a break on how long this jury's been out deliberating?
This is obviously a very fractured jury, meaning that they've got such a good mix of people. Obviously, some of these jurors do not trust the DA's evidence for whatever reason. They feel that it is called into question by one or a few of them. It could also be that they are just being meticulous and going through the evidence piece by piece. There were a lot of exhibits. It could just be that they're very thoughtful.
All right. Well, much more in this case while we continue to wait on the jury's verdict.
I want to say this. I do appreciate the prosecutor. He's being very strategic in the way that he's doing the cross-examination. He's questioning everything, but he's not being overly demeaning or anything like that. So he's playing his cards pretty well. And I will say this, initially I said, his demeanor was a little dry, but maybe now that I look at it a little deeper, he's trying to just display a person who had absolutely nothing to do with it. It was those two guys. I can't remember the type of hat that they had on their head, but I know there was a hat. So maybe he's trying to play it so calm that, you can't even think that he had anything to do with this.
Philip, your thoughts? If that was your client up there, how's he doing?
Well, to be quite candid with you, I think it could come off like a crock of malarkey. Some of the jurors in the back are probably just shaking their head like, why are we here? I think what breaks the momentum in a lot of the cases where we have foreign clients and foreign witnesses is that it takes so long to elicit testimony through the foreign language interpreters. So it slows down the momentum. So to be fair, that could play into how a witness could come off a little stoic and stolid. And also it gives counsel who's doing the questioning a little time to get their thoughts together, to reflect and review their notes. But on balance, it's whether or not you buy his story. The real issue is going to be why the masked men didn't kill him and why Molly wasn't shot with a gun. One of them was armed with a pistol. It would have been much cleaner, but she was stabbed multiple times. It appeared to be some type of a rage killing. Additionally, when the body was found, it appeared to be posed because, if I recall, her top and her bottom was pulled off or down, and the corn stalks were covering her face. It looked almost as if, from a criminal profiler's perspective, as if the person who did this couldn't bear to see what he or she had done, and therefore covered the body.
Judge, does it look like the defendant here is trying to come off like he's just an unwilling participant in this crime?
That's what he's trying to do. But just like Philip said, that leads to the questions of why? Why aren't you a victim? Why wasn't the gun used? So he's trying to basically say he had nothing to do with it. But the question is, again, like Philip said, well, then why did they leave you as a witness? Why would they just not close that circle there and tie that loose end? So it's hard, it's a hard one, but he's trying to stay calm. He's trying to play that role as if, I didn't do anything at all, or otherwise I wouldn't even testify.
And Philip, do you agree with the judge that this calm, collected demeanor, not to appear nervous, just a flat presentation, is that the right move for this defense?
For me, no. I need someone to show a little bit of emotion when recounting what happened so that you give some believability to the version of events. Otherwise, it looks like you're just flying from the seat of your pants. You're just spewing out whatever looks or sounds good against the advice of counsel. In my opinion, I don't think his lawyers wanted him to testify, and he came up with this bizarre, outlandish story that, frankly, turned the courtroom.
Well, I want you both to stay with us. We're going to take a break, and we'll be Public Defender Philip Dube. Philip's joining us in his personal capacity and not on behalf of the LA County Public Defender's Office. So, guys, what do you make of this? What are your thoughts on this prosecutor just laying out the facts like this? Judge?
Well, I like the fact that he's, at this stage at least, he's focusing on everything that he said. He doesn't want to go back to this theory of other people and being involved. He doesn't want to go back to things that take him away from the scene. He's saying, look, he said earbuds, they were on his lap. He said that. So really, when you arrow in on that, it takes away any doubt that he was involved. He had to be, because otherwise the personal items wouldn't be on them. The fact that, the boyfriend bought the earbuds. I mean, all these things are really focusing in on the crime itself and the inability for the defendant to separate himself from what happened.
Wow. Philip, your thoughts?
I actually think that this prosecutor gave the defense fodder for a lesser included offense of voluntary manslaughter based upon a sudden quarrel or heat of passion type argument. And perhaps they could have asked the court for an instruction on that so the jury could at least come back on a lesser that doesn't carry life. Keep in mind that if this struggle occurred the way the prosecutor presented it to the jury, that, there was this pass that was made, he was rebuffed, she slaps him, the next thing you know, there's a scuffle, and he loses it. That is classic sudden quarrel, heat of passion. Now, whether or not the jury would buy it is another question, but it sounds to me like this prosecutor negated his own mens rea, that malice aforethought that you would need for a traditional murder.
Well, I want to go to this clip here where we have the defendant. He's being asked about being tired, being exhausted. Are those good defenses?
Blacking out is not a defense, unless you can show, right? Because you would black out after the commission of the crime. All it means is that you can't remember what occurred, and you might not be able to effectively assist your counsel in explaining what occurred so you could marshal a defense. But I think the bigger problem in this particular case is that his demeanor on the stand is just so wooden and unflappable and deadpan that it's hard to reconcile it with just some of these exciting facts that his counsel elicited from him as to what really went down by way of these two masked men. It defies logic. It, in my opinion, is turning the courtroom into summer stock.
Summer stock. Judge Dawson, your thoughts?
Well, I want to go back to what Philip said about the defense attorney creating an additional defense or a lesser included charge. And I must admit, I kind of agree with him in that regard. When you look at it from that standpoint, if there's a focus on a struggle and an action that all of a sudden happened, he lost his cool, then that's a good point. So, Philip, I want to give you your kudos on that and picking that up. And that shows that he's a good defense attorney. See, I've been wearing this judge hat a little too long because he picked up on that. And that may actually help him. But to the other point, the testimony is dry. And it depends, though. You have 3 Hispanic individuals on the jury who may identify with his type of testimony, not being comfortable with the legal system, not trusting the police, the DA, the entire system itself. So they may interpret that dryness as a bit of disconnect from the system as opposed to being guilty.
Judge, I want to ask you this because we're just getting word that the alternates have been released from the jury. What does that mean?
So basically, that means we're getting down to the nitty gritty in the sense that the people who are now in the jury room are the ones who will be deciding the case. They're going to have to stick it out through the long haul. They can't, make an excuse as to why they can't continue or, why they must go home. So the other 2 or the alternates being released now means that, hey, we're at the point where we're going to get down to this decision. And it's pretty close to the closing time, I believe.
Wow. Philip, your thoughts on that the alternates have been released from duty?
It sounds like that the jurors gave the bailiff or the court staff a question or a statement that they're either hopelessly deadlocked or they have a verdict. In either case, you don't need the alternates to be sitting around.
All right. Well, I think we'll just take a quick break now, but we could just be moments away. Let's stay with us.